Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Waetzig v. Halliburton Energy Services Incorporated. In this case, the court considered this issue. Is a voluntary dismissal without prejudice under Federal Rule of Civil Procedure 41 a final judgment, order, or proceeding under Federal Rule 60B? The case was decided on February 26, 2025. The Supreme Court held that a voluntary dismissal without prejudice under Federal Rule of Civil Procedure 41A is a final judgment, order, or proceeding within the meaning of Rule 60B, and therefore may be reopened by the district courts. Justice Samuel Alito authored the unanimous opinion of the court. The court's reasoning focused on interpreting the phrase final judgment, order, or proceeding in Rule 60B. A voluntary dismissal without prejudice qualifies as a final proceeding because it terminates the case, making it conclusive and the last filing on the docket. Although final in appellate jurisdiction contexts is interpreted narrowly, that should not be interpreted so narrowly here because Rule 60B serves a different purpose. Additionally, the term proceeding encompasses all steps taken in an action, including voluntary dismissals. To read proceeding as requiring judicial determination would strip the term of independent meaning, since judicial determinations would already be covered by order. Historical context further supports this interpretation. Rule 60B was based on a California provision that had been interpreted to apply to voluntary dismissals. The rule speaks in ascending order of generality: judgments, then orders, then proceedings, suggesting proceedings should be broader than the preceding terms. This interpretation prevents voluntary dismissals without prejudice from falling into a procedural no man's land, where they would neither be considered interlocutory nor final, leaving parties without recourse to correct mistakes in dismissal. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. Federal Rule of Civil Procedure 60B permits a court, on motion and just terms, to relieve a party from a final judgment, order, or proceeding. The question in this case is whether Rule 60B permits a district court to reopen a case that was voluntarily dismissed without prejudice under Rule 41A. We hold that such a dismissal counts as a final judgment, order, or proceeding, and thus qualifies for Rule 60B relief. This case began as an employment dispute. Petitioner Gary Waetzig is a former employee of respondent Halliburton Energy Services Incorporated following his termination. Waetzig filed a lawsuit against Halliburton in the U.S. District Court for the District of Colorado. He alleged that he was illegally terminated on the basis of his age, in violation of the Age Discrimination in Employment Act of 1967. In response, Halliburton asserted that Waetzig was required to arbitrate his claim. Waetzig acquiesced and submitted his claims for arbitration. At that point, Waetzig could have asked the district court to stay his federal lawsuit pending the arbitration proceedings. Instead, he elected to dismiss the case under Federal Rule of Civil Procedure 41A. Under that rule, a plaintiff may dismiss his case without a court order if he serves a notice of dismissal before the opposing party serves either an answer or a motion for summary judgment. Since Halliburton had not yet served an answer or moved for summary judgment, Waetzig's dismissal was effective without any court action. And given that this was the first time Waetzig had dismissed these claims, his dismissal was presumptively without prejudice. That means that Waetzig had preserved his right to refile the same claims in the future. Waetzig lost at arbitration. After a telephonic hearing, the arbitrator issued an award granting summary judgment in favor of Halliburton. In Waetzig's view, however, the arbitrator failed to follow various procedural rules required by the parties' arbitration agreement. To remedy that alleged error, Waetzig turned back to federal court. Waetzig's next move was procedurally creative. Instead of filing a new lawsuit in federal court attacking the validity of the arbitration award, he returned to the lawsuit that he had previously dismissed. He filed a motion under the old docket number and asked the court to reopen that case and vacate the arbitration award. That move created an obvious problem. As we already explained, Waetzig's dismissal under Rule 41A terminated his case. So, in theory, filing a new motion in the case was impossible. The district court was therefore skeptical of Waetzig's gambit. It issued an order asking him to show cause that would justify the court's taking jurisdiction over the motion. In response, Waetzig asserted that the district court could reopen the case under Federal Rule of Civil Procedure 60B. Rule 60B permits a court, on motion and just terms, to relieve a party from a final judgment, order, or proceeding. A court may do so for 6 enumerated reasons, including mistake, inadvertence, surprise, or excusable neglect. The general purpose of the rule, we have said, is to make an exception to finality. The rule attempts to strike a proper balance between the conflicting principles that litigation must be brought to an end and that justice should be done. Here, the district court agreed with Waetzig and awarded Rule 60B relief. First, It held that a voluntary dismissal without prejudice counts as a final proceeding and therefore falls within the ambit of the rule. Second, it found that Waetzig had committed a careless mistake when he voluntarily dismissed his case instead of moving for a stay pending arbitration or administratively closing the case. According to the district court, Waetzig did so under the false understanding that the court would retain jurisdiction over the arbitration agreement. The court thus found that relief was proper under Rule 60b, 1. And after reopening the case under that provision, the court issued a separate order granting Waetzig's motion to vacate the arbitration award. Halliburton appealed. Among other things, it argued that a voluntary dismissal without prejudice does not count as a final judgment, order, or proceeding, and therefore falls outside the reach of Rule 60b. The Tenth Circuit agreed. It reasoned that Waetzig's voluntary dismissal was not a final judgment or order because the act of dismissal required neither the entry of a judgment nor the issuance of an order by the court. The Tenth Circuit then concluded that a voluntary dismissal without prejudice could not be a final proceeding because, in its view, a final proceeding must involve, at a minimum, a judicial determination with finality. In so holding, the Tenth Circuit split from other circuits that have considered the issue. We granted certiorari to decide whether a Rule 41a dismissal without prejudice is a final judgment, order, or proceeding under Rule 60b. Before reaching that question, however, we first address a preliminary issue related to jurisdiction. Halliburton claims that the district court lacked jurisdiction over Waetzig's motion to vacate the arbitration award. In support of its argument, Halliburton points to this court's decisions in prior cases. We need not address the merits of this argument, however, because it presents no barrier to our deciding the question presented. We granted certiorari to decide whether Rule 60b permits a court to reopen a case that was voluntarily dismissed without prejudice. That question is separate from, and antecedent to, the question whether the district court could exercise jurisdiction over Waetzig's motion to vacate. The cases Halliburton cites prove the point. In one case, we addressed the jurisdiction of the federal courts to consider motions to vacate arbitration awards filed under a provision of the Federal Arbitration Act. We held that a plaintiff seeking to vacate an arbitration award must point to an independent jurisdictional basis that would authorize a federal court to decide the matter. In another case, we suggested that Rule 60b cannot confer jurisdiction upon a federal court where jurisdiction would not otherwise exist. We reasoned that reopening a case under Rule 60b would not automatically confer jurisdiction over a subsequent motion to enforce a settlement agreement. The upshot of our analysis was that, even though Rule 60b might give a court the power to reopen a case, the rule cannot itself serve as the basis for federal jurisdiction. Although these cases might bear on the district court's jurisdiction over Waetzig's motion to vacate, they say nothing at all about whether the district court had the power, under Rule 60b, to reopen Waetzig's case in the first place. That power is the focus of our decision today, and it must be addressed before any subsequent jurisdictional questions are considered. The procedural history of this case confirms as much. Before the district court could rule on Waetzig's motion to vacate, it first needed to reopen his case. Consistent with that understanding, the court issued two separate orders. First, an order reopening the case pursuant to Rule 60b, and second, an order vacating the arbitration award. We granted certiorari to address the district court's power to issue the first order, not its jurisdiction to issue the second. We leave it to the lower courts to address any subsequent jurisdictional questions on remand. That brings us to the question presented. Rule 60b permits a court to relieve a party from a final judgment, order, or proceeding. We hold that a Rule 41a voluntary dismissal without prejudice qualifies as a final proceeding under Rule 60b. Text, context, and history support that interpretation. To start, we hold that a voluntary dismissal without prejudice is final under Rule 60b. In 1946, when the term final first appeared in the rule, legal dictionaries defined final to mean definitive, terminating, completed, conclusive, last. By way of illustration, legal dictionaries defined final order as an order that terminates the action itself. A voluntary dismissal without prejudice falls comfortably within this definition. The dismissal is the conclusive and last filing on the docket, and it completes the particular lawsuit at issue. And, like a final order, the dismissal terminates the action itself. That straightforward reading of final is confirmed by the Federal Rules Advisory Committee's notes, which are a reliable source of insight into the meaning of a rule. In the notes accompanying the 1946 amendments to Rule 60b, the committee briefly explained its reason for adding the term final. According to the committee, the addition of final clarified that interlocutory judgments are not brought within the restrictions of the rule, but rather they are left subject to the complete power of the court, rendering them to afford such relief from them as justice requires. The term final was therefore intended to exclude interlocutory judgments from the reach of the rule. And, as the committee notes explain, that exclusion makes sense. Rule 60b relief from interlocutory judgments is unnecessary because, with respect to those judgments, a rehearing may be sought at any time before the final decree, provided due diligence be employed and a revision be otherwise consonant with equity. In other words, a court presiding over a case is always capable of revising an interlocutory ruling, so long as a revision is consonant with equity. After a case is finally terminated, however, a court no longer presides, and a party can no longer seek a rehearing on an interlocutory judgment. It is at that point that a court's power under Rule 60b kicks in, permitting the court to look back at the final act in a case and provide relief from that act when appropriate. A voluntary dismissal without prejudice is one such final act. It terminates the case and strips a court of its equitable power to revise its earlier rulings. At that point, Rule 60b is the appropriate avenue for relief. A contrary interpretation would place voluntary dismissals without prejudice into a procedural no-man's land. Such dismissals would not be interlocutory in the manner that the committee notes discuss because they are outside of a court's complete power over an ongoing case, nor would they be final and thus subject to Rule 60b. Halliburton provides no evidence supporting the existence of any third category. If a voluntary dismissal without prejudice is not interlocutory, then it is hard to imagine that it could be anything but final. Halliburton nevertheless presses for a narrower definition of final. Specifically, it asks the court to construe final in Rule 60b to mean essentially what it means in jurisdictional statutes, like 28 U.S.C. Section 1291, which gives the courts of appeals jurisdiction over appeals from final decisions of district courts. This grant of appellate jurisdiction can be traced back to the first Judiciary Act, and long before the adoption of Rule 60b, this court had developed a rich jurisprudence explaining the meaning of final as it relates to appellate jurisdiction. Halliburton asks us to look to that legal lineage when interpreting Rule 60b. Based on that body of case law, Halliburton contends that a determination is final principally when it terminates the litigation between the parties on the merits of the case. Contrary to Halliburton's suggestion, however, we do not find this body of case law helpful in interpreting the meaning of the term final in Rule 60b. True, we sometimes look to legal tradition when interpreting a statutory term, but we typically do so only when the term is obviously transplanted from another legal source. Here, there is little reason to think that the term final in Rule 60b was transplanted from statutes governing the jurisdiction of federal appellate courts. In that field, the concept of finality plays a distinctive role. It prevents interlocutory appeals from unduly impairing the resolution of civil and criminal cases at the trial level. Under 28 U.S.C. Section 1291 and predecessor provisions, a party that loses in the district court has a statutory right to take an appeal from any final decision. Our decisions defining what the term final means in this context have imposed an important practical limit on such appeals. We have described the finality requirement as the means for achieving a healthy legal system. Without it, too many trial court rulings could be appealed, and the orderly progress of a cause would be halted while the appellate court considered all sorts of questions which have happened to cross the path of such litigation. Finality under Rule 60b does not play a similar role. Unlike an appeal filed under the appellate jurisdiction statute, a motion for relief under Rule 60b is discretionary, not a matter of statutory right. Further, Rule 60b relief is unnecessary when a case is ongoing because during that time, a court retains jurisdiction to review and modify its decrees. Thus, there is no reason to fear that Rule 60b will be abused to bring about a halt in the orderly progress of a cause. And, even if such abuse were possible, Rule 60b provides district courts with ample discretion to prevent it. Given these stark contextual differences, it is unlikely that final as it appears in Rule 60b was transplanted from the appellate jurisdiction statute. We therefore see no reason to import the understanding of finality that applies in the field of appellate jurisdiction. In the context of Rule 60b, a voluntary dismissal without prejudice is final because it terminates the case. Next, we hold that a voluntary dismissal without prejudice counts as a proceeding under Rule 60b. In 1938, when the term proceeding first appeared in the rule, Black's Law Dictionary defined proceeding as the form and manner of conducting judicial business before a court or judicial officer, regular and orderly progress in form of law, including all possible steps in an action from its commencement to the execution of judgment. Other dictionaries define the term similarly. These definitions suggest that the term proceeding encompasses all steps in an action, including the filing of papers that are noted on the docket. Even today, Black's Law Dictionary defines proceeding as the regular and orderly progression of a lawsuit, including all acts and events between the time of commencement and the entry of judgment. Other federal rules similarly treat proceeding as including all formal steps taken in an action. Take, for example, Federal Rule of Civil Procedure 37. Under that rule, a court may stay further proceedings in a case until a discovery order is obeyed. In that context, A stay of proceedings likely refers to a stay of any further action in the lawsuit, including further docket filings. If read otherwise, the stay would be an ineffective sanction against a party's disobedience. Similarly, Rule 41 permits a court to stay the proceedings until a plaintiff pays the costs of a previously dismissed action. As with Rule 37, that would be a relatively toothless sanction if proceedings did not encompass all further actions in the case. Halliburton and the court below offer an alternative definition. They argue that the term proceeding is given more precise content by the neighboring words with which it is associated. Specifically, they assert that the term proceeding should be read to include the characteristics of the terms that come before it, judgment and order. Since a judgment and order both involve some judicial determination of rights, they say, a proceeding should at least involve some judicial action or conclusive determination of rights. Although it is true that statutory terms must be read in the context of their neighbors, that rule cuts the other way here. To read proceeding to require a judicial determination would strip it of any independent meaning. Any formal judicial determination of a party's rights is bound to be in order. So, if the term proceeding covers only judicial determinations, it is hard to imagine what the term proceeding would encompass that is not already covered by the term order. Such a limited reading of proceeding is contrary to the general structure of Rule 60b. When the rule authorizes relief from a judgment, order, or proceeding, it speaks in an ascending order of generality. It starts with the narrowest category, judgments, and then moves to a broader category, orders. Any judgment will generally involve an order, but not all orders are judgments. That suggests that each term should be read as broader than what came before. Just as order encompasses and exceeds judgment, proceeding should encompass and exceed order. It would be odd, therefore, to read proceeding as covering only those acts that are already covered by the term order. Halliburton intuitively grasps this point. To avoid a complete overlap between order and proceeding, it tries to conjure up examples of what might count as a proceeding under its definition while not being an order. But in doing so, Halliburton only reinforces the common-sense conclusion that a voluntary dismissal without prejudice counts as a proceeding. For example, Halliburton suggests that a voluntary dismissal with prejudice may qualify as a proceeding. But there is no reason why a voluntary dismissal with prejudice would count as a proceeding while a voluntary dismissal without prejudice would not. Both consist in the simple filing of a paper on the docket. Halliburton contends that a dismissal with prejudice is different because it imposes legal burdens, but a voluntary dismissal without prejudice does so as well. For example, Waetzig's dismissal apparently precluded him from continuing to pursue his claims, not because his dismissal was with prejudice, but because the relevant statute of limitations had already expired. In sum, the text, context, and structure of Rule 60b show that the term proceeding encompasses all steps taken in the action, including a voluntary dismissal without prejudice. Finally, our reading of Rule 60b is buttressed by the historical context in which the rule was enacted. The original version of the rule was based on a then extant provision in the California Code of Civil Procedure. That provision permitted a court to relieve a party from a judgment, order, or other proceeding. And prior to the enactment of Rule 60b, the Supreme Court of California had read that provision to apply to voluntary dismissals. According to the California court, a plaintiff who consented to a dismissal to his injury, under a mistake of fact, excusable under the terms of the statute, is not barred of relief, and the California court made clear that the existence of prejudice was immaterial. Whether a voluntary dismissal bars a future action need not be considered. If the plaintiff is entitled to relief under the statute, it is not material whether, in its absence, he could have relief either at law or in equity. When read in light of this history, it makes sense that Rule 60b would likewise extend to voluntary dismissals without prejudice. The provision was expressly modeled after a statute that ostensibly permitted such relief. And although the rule has been amended substantially since then, the amendments have always retained the original candidates for relief, judgments, orders, or proceedings. To be sure, the rule now specifies that the judgments, orders, or proceedings must be final. But, as we have already explained, the term final does not exclude voluntary dismissals without prejudice from the reach of the rule. There is no reason to think, then, that such dismissals have since escaped the rule's coverage. For the above reasons, a Rule 41 of voluntary dismissal without prejudice counts as a final proceeding under Rule 60b. When the requirements of Rule 60b are satisfied, a district court may relieve a party from such a dismissal and reopen the case. We express no view on whether that relief was proper in Waetzig's case, nor do we reach the question whether the court below could exercise jurisdiction over Waetzig's motion to vacate the arbitration award. Those questions are left to the court below on remand, to the extent the relevant arguments have been preserved. The judgment of the 10th Circuit is reversed, and the case remanded for further proceedings consistent with this opinion. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.